Good morning and good afternoon, everybody. Thank you for participating in this joint webinar of the Law Society of Hong Kong and the German Federal Bar. Before we start with our first item on the agenda, please allow me to give you a short technical introduction. This webinar, you're automatically muted and are listening. You are in the listening mode only. Please also note that this webinar is being recorded, and later you can visit the website of the Law Society of Hong Kong and refer to the webinar. It will be shared there. The chat room allows you to send chat messages to the hosts, panelists, and attendees. And if you have any questions for the speakers, please feel free to type your question in the Q&A box during or after the presentations. I will be reading the questions aloud after our experts finish their presentation, and the panelists will have sufficient of today's webinar. So our program is divided into 3 parts. The first part, our German experts will talk about the situation in Germany. In the second part, our colleagues from Hong Kong will share with us expertise about the situation in Hong Kong. In the third part, the participants are invited to ask questions, and we will have a Q&A session. So, and now I would like to invite Vice President of the German Federal Bar, André Haug, for his greeting remarks. So, André, please, the floor is yours.
Thank you, Svetlana, and hello, everybody, dear experts, dear participants of today's webinar. A warm welcome to all of you on behalf of the German Federal Bar to our joint online event on the topic of anti-money laundering regulations, organized by the Law Society of Hong Kong and the German Federal Bar. Allow me to shortly introduce some facts about our organization, the German Federal Bar. We are the central representative body of the legal profession in Germany and the umbrella organization of the 28 regional bars. With 167,000 lawyers, the legal profession in Germany is one of the biggest in Europe. We have a mandatory membership system. This means that every lawyer in Germany has to become a member of a regional bar when he wants to practice law in Germany. The German Federal Bar safeguards the professional interests of the whole advocacy in Germany on a federal, European, and international level. We have been actively involved in the development of the legal profession and the rule of law in Germany and other countries for many years. With proceeding globalization, our international activities keep intensifying. Up until today, we are highly involved in international matters concerning the advocacy worldwide. The latest developments we have made in the North African region. Nevertheless, a major focus of our international work still lies with Asia, as we believe that the development of the legal profession in Asia will gain more and more influence on the developments in Europe and vice versa. The Law Society of Hong Kong has been our important partner for many years. In 2016, the German Federal Bar and the Law Society signed a cooperation agreement. Since then, a very reliable and stable partnership has been developed. Both organizations engaged in numerous bilateral meetings and workshops in Asia and Europe over the past years. We covered topics like digitalization of the judiciary and legal tech. We also exchanged our views on the developments within the legal profession during the COVID-19 crisis. Due to the pandemic, we had to switch to the online format, and today's webinar is the second joint event we are holding together. I'm happy to see that online events still enjoy popularity and that we have so many participants. The topic of today's webinar, anti-money laundering regulation, has gained importance during the past 2 years in Germany. New regulations have been enacted and the regional bars had to adopt a system of supervision over the legal profession. The German Federal Bar created a new committee in this field of law, and further regulations are being developed right at this moment. But all this You will hear from our experts. I'm very interested to hear about the developments in Hong Kong in this regard. And now I wish all participants an interesting and pleasant event. Thank you very much.
Thank you, Andre Haug, for this warm welcome. And now I would like to hand over to our colleagues from Hong Kong. Unfortunately, Mr. CM Chen could not be with us during the webinar, but we have recorded his greeting remarks, and I would like to ask the Law Society to play the video.
Mr. Andre Haug, Dr. Christian Lemke, Vice President of the German Federal Bar, distinguished speakers, members of the Law Society of Hong Kong and the German Federal Bar, good day or good evening, depending where you're from. It is my pleasure to welcome you all to today's joint webinar. Exploring business opportunities for members is an important task of the Law Society of Hong Kong. Throughout the years, we have established extensive connections with the legal profession organizations in various jurisdictions, laying a good foundation for collaboration on activities that are beneficial to the respective members. We have been working closely with the German Federal Bar over the years to advance the legal profession in both jurisdictions. To formalize our commitments to collaborate and support each other, a memorandum of understanding was signed in May 2016. And I met with your chairman only just 2 months ago in Australia in person. The pandemic has brought a near halt to international travel and most of the physical activities over the past 2 years. Fortunately, with the help of technology, we are able to retain connected, unhindered by geographic separation. Further to the joint webinar on law tech successfully held in September 2021, we are happy to have the opportunity to work with the German Federal Bar for another joint webinar today. It is encouraging to know that over 70 members are joining us today to know more about the anti-money laundering regulation and the supervision of the advocacy in Germany and Hong Kong. As an international financial center, Hong Kong attaches great importance to safeguarding the integrity of our financial systems by implementing the international standards on anti-money laundering and counter-terrorism financing to deter and detect inward and outward flows of illicit funds. Hong Kong is an active member of prominent international bodies focusing on combating money laundering, such as a member of the Financial Action Task Force, FATF, FATF in short, since 1991, and a founding member of the Asia-Pacific Group on the Money Laundering since 1997. In particular, the Financial Action Task Force conducts peer reviews, we call it mutual evaluations, of each member on an ongoing basis to assess how each jurisdiction is performing in preventing criminal abuse of financial system. The assessment result is considered an important factor in evaluating a jurisdiction's international reputation as a financial center, as it reflects the level of integrity of its financial system. The mutual evaluation of Hong Kong took place in 2018, and the report was published in September 2019. The report, which assesses the compliance and effectiveness of Hong Kong's anti-money laundering and counter-terrorism financing regime against the international standards, confirms that Hong Kong has a strong legal foundation and effective system for combating money laundering and terrorist financing. Such AML-CFT, as I call it in short, regime is assessed to be compliant and effective overall, making it the first jurisdiction in Asia-Pacific region to have achieved an overall compliant result in the round of Financial Action Task Force evaluation. Focusing on AML effort has become increasingly a global trend to the extent that measurable AML effort could have an impact on the international ranking of a city on the world stage. Over the years, the Law Society of Hong Kong has devoted significant time and effort during its negotiation with the government and other relevant authorities, including Financial Action Task Force, on the application of appropriate AML measures with a view to protecting the integrity of the profession and upholding the reputation of the legal sector in Hong Kong. The AML landscape in the legal sector is changing, with an increasing awareness of the multitude of ways in which legitimate services provided by law firms can be used for illegitimate purposes. To ensure law firms have adequate controls in place to mitigate such risks, the Law Society of Hong Kong is sharpening its supervisory focus on the measures put in place by member firms to implement AML checks and report suspicions. These include the launch of the AML Review, which is the first sectoral money laundering and terrorist financing risk assessment of legal profession, development of AML Toolkit, and the launch of a comprehensive AML web page, which will serve as a resource hub for our members regarding AML. I shall leave the time for the two Law Society representatives, Ms. Corinne Wong and Ms. Hin Hang Shum, to introduce the latest development of AML regulation in Hong Kong and the Law Society of Hong Kong's efforts in this area. I hope you will find our joint webinar to be an informative and rewarding experience, and I would welcome ideas on how to further explore future collaboration between the two jurisdictions. Please enjoy the rest of the event, and hopefully we can meet again very soon in either in Hong Kong or Germany, hopefully in person. Thank you, and may I wish you all an early Merry Christmas. Thank you.
Thank you very much also for those greeting remarks. Now I would like to invite Dr. Christian Lemke, Vice President of the German Federal Bar, to give us an introduction of the lawyers as obliged parties, under the Anti-Money Laundering Act in Germany. Dr. Lemke is Vice President of the German Federal Bar since 2019. He was admitted to the bar in 1993 and has been a partner in the law firm Heiser & Struck in Hamburg since 1996. He specializes in intellectual property law, data protection law, IT law, copyright law, competition law. He is a specialist lawyer in intellectual property law and information technology law. Dr. Lemke has been on the board of the Regional Bar of Hamburg since 2006 and its vice president since 2009. Since 2018, he is president of the Hamburg Bar. He is a member of the BRAC IT Law and Europe Law Committees, headed the German delegation of the Council of Bars and Law Societies of Europe, in short the CCBE, from 2015 till 2017, and is vice chair of the CCBE's Future of the Legal Profession and Legal Services Committee, and a member of the CCBE's IT Committee. Since 2019, he has been a member of the Stakeholder Advisory Board of the European Union Intellectual Property Office. Dr. Lemke, please, the floor is yours.
Well, hi, Svetlana. Thank you for all these flowers. Ladies and gentlemen, dear colleagues, I welcome all participants from Hong Kong and Germany. You dialed into today's webinar, and hello from the beautiful, free and Hanseatic city of Hamburg to the even more beautiful Hong Kong. In my presentation, I would like to inform you about the current developments in the anti-money laundering regulations, and in particular about their impact on the legal profession. German anti-money laundering regulations were first enacted in 1993, the year that I've been admitted, and have been regularly revised and expanded since then. The German Anti-Money Laundering Act, or AML Act, came into force in June 2017 and implemented the fourth EU Money Laundering Directive of the European Parliament and of the Council of May 2015. The law was updated as of January 2020. The current AML law implements the fifth EU Money Laundering Directive adopted in April 2018. With the Transparency Register and Financial Information Act, which came into force on 1st of August 2021, the German AML Act has most recently undergone further amendments. Like all anti-money laundering regulations, the Act sets out our monitoring and reporting obligations. They apply not only to companies in the financial sector, but also for tax advisors, gambling providers, real estate agents, and under certain conditions, lawyers and notaries. Unlike tax advisors and auditors who are always obliged to monitor the risk of money laundering activities of their clients, lawyers are only subject to the AML Act if they provide specific services to their clients. These activities apply to lawyers where they participate, whether by acting on behalf of or for their clients in any financial or real estate transaction, or by assisting in the planning or carrying out of transactions for the client concerning, first, buying and selling of real property or business entities, second, managing of client money, securities, or other assets, third, opening or management of bank, savings, or securities accounts, fourth, organization of contributions necessary for the creation, operation, or management of companies, or fifth, creation, operation, or management of trusts, companies, foundations, or similar structures. Covered also lawyers insofar as they advise the client with regard to the client's capital structure, industrial strategy, or related matters, provide advice or service in connection with mergers or acquisitions, or provide tax consultancy services in the course of their professional activities. In terms of figures, the status of an obliged person, a person under the German AML Act applies to only about 30% of the German lawyers. The reason for this is the limited scope of activities and services provided to clients concerning their financial affairs. Whereas auditors and tax advisors gain a comprehensive insight into the economic and personal circumstances of the client, who must always disclose all his financial circumstances, this is not true for lawyers. The vast majority of clients do not provide insight into the origin of assets and financial circumstances. On the contrary, many clients seek advice in areas of law that have nothing to do with their financial assets, such as media law, sports law, advertising law, pharmaceutical law, medical law, Tennessee law, traffic law, or the like. However, as soon as a lawyer is active in one of the fields of activity just mentioned, he is subject to the German AML law. In principle, all persons subject to the AML Act are subject to reporting obligations. However, an exemption to the reporting obligation exists for lawyers in the context of legal advice and litigation. However, it would not make sense if lawyers were subject to the law on the one hand and be exempted from the reporting obligation under the AML Act on the other. So what has the legislator done? The legislature has enacted a renewed exemption to the exemption, i.e. the reporting requirement for lawyers revives if the lawyer knows that the potential client has used or is using the legal advice or legal representation for the purpose of money laundering, terrorist financing, or any other criminal offense. The lawyer must have positive knowledge of the unlawful source of money, and he must be asked by his client to invest the money profitably. If this is the case, the lawyer would not only have to refuse the mandate, but also report his client. He should not report mere suspicion, but certainty that money laundering is planned. However, as you can imagine, such reports are very rare in practice. Furthermore, typified real estate transactions are always subject to reporting obligations. As already mentioned, the Federal Ministry of Finance has issued an ordinance on matters in real estate sector subject to reporting under the AML Act, according to which the lawyer must always file a report when acquiring real estate for his client. The German AML regulations aim to avoid a breach of the duty of confidentiality. However, as the above cases show, the duty of confidentiality is undermined by the provisions of the AML Act. These breaches of the lawyer's duty of confidentiality or attorney-client privilege are viewed very critically by the legal profession and the German Federal Bar. Legally and politically, lawyers' duty of confidentiality or lawyer-client privilege has always been a strongly protected asset but due to international pressure, German politics and legislators are increasingly moving to undermine this principle. The German Federal Bar considers the reporting obligation associated with the acquisition of real estate to be too far-reaching and even unconstitutional. In our opinion, the daily work of lawyers is increasingly burdened by obligations without any additional benefit being demonstrated. In the German Federal Bar's view, the German legislators' plans go far beyond the obligations contained in the EU regulation. Another point criticized by the German Federal Bar concerns the processing of suspicious activity reports under the AML Act. In 2017, a federal authority, the Financial Intelligence Unit, or FIU for short, was created based at Customs and subordinate to the Federal Ministry of Finance. The FIU is designed as a purely administrative authority without any investigative powers. This authority only has a filtering function, which consists of receiving, collecting, or evaluating reports filed under the AML Act. Lawyers, as well as the German Federal Bar and the regional bars, report directly to the FIU via an anonymous whistleblower system. Lawyers who are obliged to report under the AML Act must register with the FIU by 2024. After registration, they are obliged to use the FIU's electronic reporting portal, the GoAML. There's much criticism of the FIU's work in Germany. According to official figures, the authority receives 300,000 reports a year from all obligated parties. However, this authority is barely able to process this huge volume of reports, and only a very small number of reports are actually followed up by the authorities. Like the other EU countries, Germany follows the approaches of the Financial Action Task Force, or FATF in short. The FATF is an intergovernmental body that, as you probably know, sets international standards to prevent money laundering and terrorist financing. Due to the international pressure from the FATF, the German government will have to take further measures and adapt its laws in the future. What these measures will look like has not yet been determined. However, the Federal Ministry of Finance has published a key issues paper. The plan is to create a central federal authority, the Federal Financial Criminal Police Office. The government is considering locating this authority with the FIU, which is already under criticism, as I just explained. The Federal Ministry of Finance is also considering issuing further regulations on the money laundering report ordinance on matters on real estate in the real estate sector and regulations in the area of corporate law. This would lead to further breaches of the duty of confidentiality. The German Federal Bar participates in professional policy discussions with the competent ministries and politicians. We publish opinions and try to get involved in the legislative process already at EU level. In addition to the other violations of the duty of confidentiality, the German Federal Bar criticizes interference in the self-administration and independence of the legal profession if the federal government pursues its plans to create a new supervisory authority with far-reaching powers of intervention and sanctions against the legal profession. We strictly reject this kind of approach. The independence and self-administration of the legal profession has been one of the supreme principles of the legal profession since the founding of the German Federal Bar. Like Germany, the other EU member states currently still have their own national anti-money laundering regulations in force. However, the EU is already drafting directives that will, other than regulations, be directly applicable in all member states and will override the existing regulation. So far, the only major change mentioned in the EU regulation is the creation of a new supervisory authority. However, we cannot say with certainty what other changes might be introduced in the course of the future legislative process. That was a brief introduction to the situation in Germany, and you will learn more from my esteemed colleague, Laura Funke, about how the regional bars implement the supervisory system of the legal profession. So it's now Laura Funke's part from the even more beautiful city of Munich. Thank you.
Dr. Lemke, thank you very much for this introduction. And I would like to give the word to Laura Funke and also a short introduction. Laura is a legal officer of the Regional Bar of Munich, responsible for the anti-money laundering supervision and the professional supervision. She studied law in Munich and finished her legal traineeship at the Higher Regional Court of Munich. During her studies, she has been working at the Ludwig Maximilians University in Munich at the chair of German, European, and International Criminal Law and Criminal Procedure Law. And she is with the Regional Bar of Munich since 2019. Dear Ms. Funke, please, the floor is yours.
Thank you so much, Svetlana. Good morning, good afternoon, ladies and gentlemen. I am honored to be invited to speak in front of so many dear colleagues abroad. I am grateful to my colleague, Dr. Christian Lemke from Hamburg, who provided for such an insightful introduction to the topic of lawyers as obligated parties under the German Money Laundering Act. He already pointed out many of the difficulties we face. I am also a member of the German AML working group initiated by the German Federal Bar, which is responsible for the national coordination of AML supervision for the German Advocacy. So I'll be talking to you about my professional practical experience with regional AML supervision in the legal profession. So I will have to rely heavily on Munich as an example. So I'm sorry for that. With more than 23,000 members, the Munich Bar is the largest of the 28 regional bars in Germany. Whenever you read a report about money laundering in Europe, you will sooner or later come across the information that Germany is a money launderer's paradise. This is supported by an estimated 100 billion euro assumed to be laundered through our country every year. Well, not even our Federal Ministry of Finance knows exactly where that number comes from or how it was calculated. However, many treat it as a fact that all combating measures are based upon. So as predicted in this year, the FATF once again attested Germany over a good compliance, but still severe problems in implementing international requirements to fight money laundering. Germany consists of 16 federal states, with overall, allegedly, more than 300 different AML supervision authorities. Responsible for the supervision of the advocacy are the regional bars. There are 28 such regional bars, which in theory are completely independent in their individual approach to their AML supervision. The relevant legal framework is the same for every regional bar. We all have to act according to the Money Laundering Act, the Administrative Offences Act, and our professional legislation. But it's still up to the individual bars how the supervision is implemented. Due to this structure, we are facing some typical problems within the legal profession. A lawyer may have several offices in several federal states, or a large multinational law firm may have many offices in several federal states. To ensure optimal compliance with the law, a uniform standard of supervision is needed. To tackle this problem, in 2017, the German Federal Bar established a working group for money laundering supervision in which each regional bar can participate. This working group meets approximately 4 times a year and is responsible for the national coordination of AML efforts of regional bars. Some of our tasks are quite administrative in nature, so we coordinate the procedure of our annual survey, and this includes an agreement on the relevant percentages of lawyers we aim to audit. In addition, of course, we have to implement any changes of the law that happened in the meantime, but other tasks of our working group are rather creative. So since neither there is a large amount of literature concerning AML duties and advocacy, nor is there any kind of jurisprudence on the issue. So far, we are still waiting for judgments for cases that have started in 2018. So therefore, we have to try to find solutions for open legal questions in a group effort. And it works pretty well, if I may say so. We also educate each other in regional specifics. So for example, from our colleagues in Hamburg, we all learned a lot about potential money laundering through the construction of luxury votes. To ensure a somewhat uniform approach towards AML supervision, all regional bars, as well as the federal bar, are in quite constant exchange with other supervisory authorities. The federal and state ministries, public prosecutors' offices, the police, the financial intelligence unit, and lawyers' associations. So we try to try a roundabout approach to money laundering efforts to combine our shared knowledge. The German Money Laundering Act aims for preventive and not for repressive measures. Its aim is not to investigate actual crimes of money laundering or terrorism financing. Those are duties that still remain firmly with the police and the prosecution. The Money Laundering Act aims to prevent that the obliged parties are unknowingly used for criminal purposes by their clients. Due to the so-called gatekeeper function of the legal profession, it is important that lawyers have knowledge of relevant typical strategies of money laundering, as well as the measures to prevent them. One of our senior financial crimes prosecutors stated that there is rarely a prominent case of money laundering without one or several lawyers being involved. We do realize that as a mere supervisory agency, we will not be able to investigate or even identify all cases in which the client and the lawyer knowingly and intentionally work together in committing money laundering. However, we also receive information by our financial intelligence unit and the prosecution office concerning transaction on the at least questionable side of legality. We do indeed have one or two cases with thousands of pages of evidence, which also raise questions towards the AML obligations of the parties involved. The management of such quasi-criminal cases is a big challenge for us, since we do not have the resources the police has to handle such matters. As a consequence, in such cases, AML supervision also requires improvisation and coordination between different authorities. Generally, supervision is based on a dual structure. On the one hand, the supervisory agencies provide information and support, and on the other side, we survey and investigate the obligated parties. For general information, the regional bars annually organize several lectures and trainings concerning AML duties for lawyers, as well as their office staff. We also provide information and material on our official websites, for example, guidelines for identification, the national risk analysis, or a summary of AML duties for clients. The regional bars also offer to consult on AML duties. In Munich, for example, we have approximately 5 calls a week by our lawyers, but many more once the annual surveys start. The central document the federal and regional bars agreed upon are directives for interpretation and implementation of AML duties. This document is basically a legal commentary aimed specifically at the advocacy to provide guidelines for implementing AML duties. It's revised annually by the AML working group to implement changes of law, provide clarifications, and general progress of the shared AML knowledge. For our survey, every year 10% randomly chosen members of a regional bar get a preliminary survey to ascertain whether they were obligated parties under the Money Laundering Act. It is mandatory to take part in the survey. In Munich, we sent this preliminary survey to approximately 2,500 lawyers. The core question of the survey is whether the lawyer participated in the relevant transactions characterized by Christian Lemke, real estate transactions, trusteeship, tax auditions, and so on. In addition, the survey contains questions concerning the specific field of legal praxis, e.g. criminal law, administrative law, M&A, tax law, as well as potential high-risk factors. The Money Laundering Act is based on a risk-based approach, so our supervision aims to implement this approach. While on the one hand, we have to conduct random controls, demonstrating that no lawyer is exempt from supervision. On the other hand, we have to factor in how likely it is that a certain lawyer may be facing risk of being used for money laundering purposes. Approximately 35% of those 10% of all members are obligated parties under the Money Laundering Act. In Munich last year, this amounted to about 820 lawyers. From those 820 lawyers, 25% have to take part in a second survey, the actual AML control. To implement the risk-based approach, the answers from the preliminary survey get assigned certain points, contingent on the specific abstract AML risk a professional activity poses. Real estate transactions and transactions with connections to high-risk jurisdictions, for example, get assigned a high risk, while tax law cases without any additional risk factors get assigned a lower risk. This way, we create 4 different groups: high risk, medium low risk, and low risk. We aim to survey 50% from the high risk, 25% from the medium high risk, 15% from the medium low risk, and 10% from the low risk group. This way, no one is exempt from a potential survey where we still satisfy the requirement of a risk-based approach. Additionally, 5% of those lawyers who answered that they were not obligated parties get validated by a thorough research into their professional conduct. This way, we try to prevent an easy out by purposefully giving wrong answers. The research includes their personal files, as well as office websites, social media entries, or professional publications. We then send a second survey to the obligated parties. It consists of yes or no questions concerning all relevant AML duties for the legal profession. For example, in cases where your client was a natural person, did you identify said client via a valid ID card, a piece of identification, or an electronic proof of identity? There are few AML duties that do not concern individual clients or transactions, but apply during the entire status as obligated party. These are the only possible infringements where the questionnaire alone is reason enough to start administrative proceedings. This is possible, for example, in cases where the question, did you compile a risk analysis for your practice, is answered with no, because no further establishing of facts is necessary or even possible. Either I do have a risk analysis or I do not have one. In all other cases, the answer to the fulfillment of an obligation is no. Further clarification is necessary. And at this point, we deviate from our uniform approach toward all obligated parties who until now have all received exactly the same kind of questions, and switch to individually written communication. While we do prepare text modules for certain constellations, we now have to pose individual questions tailored to the specific information we have. If, for example, someone has answered no to the question concerning the identification via ID card, we now have to clarify whether none of the clients was identified or only some of them, and whether no means I did not see the ID, but I have noted all relevant data and verified it with some random document, or if it means my client was basically anonymous. We also regularly request relevant documentations, often only the written risk analysis, but sometimes the entire case file. The entire process takes usually about a year. We aim to develop the new questionnaires in January and February, send out the first survey in March, April, and the second survey in June or July. The second half of the year, we try to answer any follow-up questions. Due to the high number of lawyers, we use an online tool for our questionnaires. Our lawyers get an individual code that enables them to complete the questionnaire. The regional bar is the only one who can match the code to the individual person so that we can ensure compliance with data protection requirements. In the preliminary survey, the possible answers are not liable for interpretation, so we mostly evaluate them automatically. The second survey offers too many opportunities for misunderstandings, so we evaluate them individually. With approximately 10% of all lawyers surveyed, we conduct an on-site audit in their offices. We can't do this with everyone because it's pretty time-consuming, but the easiest way to verify whether or not the given answers are actually true. It's also often easier to clear up misunderstandings in person than through a lengthy exchange of documents. It's also a viable alternative to invite the obligated parties to the bar's office and let them bring the relevant documents. As a supervision authority, we are allowed to enter the premises, look at any documents presented, and also to request specific files, but we are not allowed to conduct a search. This can only the police do. And so as a part of the risk-based approach, alongside the routine surveys, the regional bars conduct specific surveys whenever there's a reason to suspect a lawyer might not have complied with AML regulations. Such a reason might be a professional complaint, criminal or civil proceedings against the lawyer, a report by the Financial Intelligence Unit, but also media reports concerning lawyers or law firms. If this reason already confirms the lawyer is an obligated party, for example, because there are reported irregularities concerning the trusteeship of larger sums of money, we can start directly with an in-depth investigation. In all other cases where the problematic activity is not directly linked to AML duties, we still have to put the confirmation first that the lawyer is indeed an obligated party. In all incident-based cases, we usually also conduct an on-site visit and often even start with this. The regional bars also act as regulatory offences authorities. As such, we can impose regular fines up to 150,000 euros per infringement. If it's a grave, repeated or systematic breach of law, we can impose fines up to 1 million euros. These amounts are still the same for all obligated parties. So the higher end range of potential fines is rather employed by huge supervisory agencies responsible for legal entities like the banking supervision. So far in Munich, we have imposed about 120 fines that have become final. An additional 30 to 50 fines are currently pending. The fines so far range from about 100 euro to about 15,000 euro. On a first glance, this seems to be rather low. However, the regional bars oriented themselves to other AML supervisory agencies. The advocacy should be neither worse nor better off than other natural parties as obliged parties, such as notaries, tax consultants, auditors, or goods dealers. It is also important to note in this context that the current Money Laundering Act only came into effect in 2017. Accordingly, the first AML survey was executed in 2018, 5 years ago. The first 2 years, we were hesitant to impose fines for 2 reasons. Firstly, we couldn't expect the advocacy to be proficient in AML measures when the supervisory agencies themselves only just had realized how exactly those duties should be implemented. In favor of our obligated parties, we assumed that the lawyers simply didn't know their AML duties yet, and we were quite lenient. We pointed out which mistake they made and mostly worked with warnings. Secondly, the legislator simply forgot that without an explicit regulation, the question whether or not an AML supervisory agency was also the competent regulatory offences authority was dependent on the federal state's law. Accordingly, we had 16 different relevant regulations with about 1/3 of the regional bars being able to impose fines, while 2/3 were not competent to do so. Then the outcome would have been that a Munich lawyer would get fined for an infringement. A Düsseldorf lawyer would only get a warning for. The regional bars decided via the AML working group that all regional bars would abstain from imposing fines until the matter was settled by the federal government. And indeed, the law was changed 2 years later to enable all regional bars to effectively sanction AML deficiencies. Nowadays, we try to balance our sanctions between having a deterrent effect and the actual risk the violation poses to AML purposes. Our most common infringement is the omission of a risk analysis. This happens most often with lawyers who are working alone and work on maybe 1 or 2 relevant transactions a year. It's often legal advice concerning tax returns or real estate transactions for long-time neighbors, especially in more rural areas. The fines imposed should reflect that such transactions do have an abstract risk potential and that AML duties are not dependent on individual risk. At the same time, however, we do include the fact that the individual transactions in question did not pose a real AML risk, so that individually, the omitted risk analysis had the character of more a formal breach. Had a corporate lawyer in a large law firm committed the same breach, we probably wouldn't be quite so lenient, since such firms are obliged to have corporate-wide AML systems in place. Also, a corporate lawyer usually faces a far larger risk, since it's far more likely that they don't know the client personally and can't grasp the entire transaction at a glance. For example, in huge M&A transactions, it's hard to see if there is a risk potential or if there is not a risk potential. The largest fines so far were imposed for non-compliance with the obligation to cooperate, to answer our questions, and to send in requested documents. Every year, we have several lawyers who do not send back their questionnaires, even after several written reminders. Since this is the easiest option to entirely thwart any AML supervisory measures, we treat this kind of non-compliance as a rather grave breach of law. Oftentimes, the formal hearing already proves threatening enough to induce compliance. Since we have to monitor whether the imposed sanctions are effective, lawyers who have been fined afterwards end up on a monitoring list. 2 or 3 years later, they once again will be part of an AML survey. If we do find another AML violation, the fine will be far higher than the first time. If it's the same violation as before, we will consider to apply the higher penalty frame. In practice, the regional bars in Germany currently face a difficult situation. We try to balance genuine AML efforts with providing advice to all lawyers, while at the same time having to control them and keeping the national and international considerations to infringe upon the advocacy self-administrative bodies at bay. Rather than deliberately evaluating the framework often changes faster than we can manage to implement it. At the same time, we face heavy criticism for not being thorough enough, or of fines not being high enough, and the lawyers not being compliant enough. If questioned, the federal governments hold the European Union responsible, while the European Commission mostly points towards the FATF to explain why another regulatory tightening is necessary. In this context, I am especially curious to know how the Hong Kong AML supervision is constructed and if lawyers and bar associations are facing similar difficulties worldwide. I thank you very much for your attention and wish happy holidays to everyone who takes part in some kind of end of the year celebration. Thank you.
Yeah, dear Laura, thank you very much for this very interesting presentation. And I think even you say that your job has very many administrative components. I myself worked in the compliance office before I joined the German Federal Bar, and I always feel very interested about the cases where you actually do find something, and when this case is rather big. And actually I'm a little bit jealous, because I would like to know what are the regional differences when it comes to money laundering, and you discover in which business how it looks in the very different business types in the regions of Germany. I think this is very interesting. And of course, I can also imagine how interesting it is if you find by yourself something in your region and discover how things can go. And But of course, we will still keep some questions for later for our Q&A session. And I hope, or I would like to remind all participants who are following us that after all presentations, you can type in your questions in the Q&A or in the chat function, and we can still discuss with all experts. Yeah. So we are very good in the time, and we have finished the presentation of the experts from Germany, and we now turn to Hong Kong. And I would like to invite now Ms. Karen Wong. Ms. Wong is council member of the Law Society of Hong Kong and also a member of its anti-money laundering committee. However, Ms. Wong is not only engaged with this one committee, but also with the Standing Committee on Standards and Development, the Working Party of SME firms, the International Legal Affairs Committee, and she's a guest lecturer at the Beijing University. So she's carrying a lot of hats. And I'm happy, or we are all happy to hear her presentation. Ms. Wong, please, the floor is yours.
Thank you, Lana, and thank you very much for Mr. Hogg as well as Dr. Lemke and Ms. Funk for all the very interesting and very insightful sharing. Yes, as Lana has introduced, my name is Karen Wong, and apart from being a council member, I'm also the chairperson of the Standing Committee on Standards and Development under the council. Our AML committee is actually one of the 19 committees under the Standing Committee, which I'm the chairperson. So I happen to have exposure to different areas. And today I wish to share with the audience here, I would say the changing landscape of the AML development in Hong Kong. To start with, Hong Kong has been evaluated by the FATF a number of years ago. To start with, actually earlier back in the year 2008. And at that time, Hong Kong was actually assessed or evaluated to be partially compliant. But we are happy to see that we have been subsequently assessed, and we up to like in 2012, we have actually a satisfactory level of compliance in basically all areas except one. And actually in the year 2019, as our president, Mr. CM Chen has the pleasure to share with you all, that actually Hong Kong is the only Asia Pacific jurisdiction that has achieved an overall compliance rating. Basically, the framework of money laundering in Hong Kong, I would say, could be set to comprise in 4 pieces of legislation. The first one is the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, is the CAP 615 of the laws of Hong Kong. Second one is the Drug Trafficking Recovery of Proceeds Ordinance, and that's the CAP 405 of the laws of Hong Kong. The third one is the Organized and Serious Crimes Ordinance, that's CAP 455 of the laws of Hong Kong. And the last but not least is the United Nations Anti-Terrorism Measures Ordinance, and that's CAP 575 of the laws of Hong Kong. So in very brief, I would say the framework that we currently have for money laundering related governance could be mostly found in these 4 pieces of legislation. And of course, these 4 pieces of legislation not only apply to the legal profession, but to different areas or different fields as well. But actually, I would say, just now I shared that our FATF evaluation could be traced back to the year of 2008. But actually, Hong Kong generally, participation in combating money laundering of terrorist financing could actually be traced back much, much earlier than that. Because we have the JFIU in Hong Kong, and that's JFIU stands for the Joint Financial Intelligence Unit, and it was set up actually back in the year 1989. So Hong Kong actually had the JFIU back in the 1980s. And it was pursuant to the Organized and Serious Crimes Ordinance and the Drug Trafficking Recovery of Proceeds Ordinance, as well as the United Nations Anti-Terrorism Measures Ordinance. Basically, under these three pieces of ordinance, the JFIU has been doing quite a lot of work in dealing with investigating or following up where there are suspicion or someone who knows that there are property that represents proceeds of crime or money that are used in connection with drug trafficking or indictable offense, etc. And for the legal profession, we have the obligation, or we are much actually used to by now, to file the suspicious transaction report with the JFIU if we do have this concern, as I shared just now. And currently, the JFIU is jointly run by staff members of the Hong Kong Police Force and the Hong Kong Customs and Excise Department. So by way of background, so currently the framework that in terms of the legislation, as well as the main contact point that we have for reporting, daily reporting, are these. But actually, the efforts of the Law Society or the Hong Kong in general, of course, is much more than that. If I may say that in this evaluation in 2019 by FADF, Hong Kong has been commented as having a sound regime to fight money laundering and terrorist financing that is delivering good results, and that was back in the year 2019. However, of course, there are rooms for us to improve, and as it follow on to say, FADF said we should enhance our prosecution of money laundering involving crimes committed abroad and strengthen supervision of certain non-financial businesses. And honestly, that DNFBP, as we say, the designated non-financial businesses include the legal profession as well. And it also observed that although Hong Kong is the only Asia-Pacific jurisdiction that has achieved the overall compliant result, we should have better mechanism in place in terms of having a risk-based AML or CFT, that's anti-money laundering or counter-terrorist financing. We should have a better mechanism in terms of risk-based AML or CFT supervision, especially in the DNFBP sectors. They observed that there is a minor gap to prevent criminals or their associates from abusing estate agents as well. So that was very brief, the history of how Hong Kong has been putting in its efforts in this area, and of also the situation that the evaluations that FADF has been assessing on us. And since the year 2019, and in view of their comments, of course, Hong Kong and through the various sectors have been putting in various efforts in dealing with any shortfall or any rooms for improvement. And of course, the Law Society of Hong Kong is no exception. So for the past few years, we have done quite a few aspects of work, and I would quickly summarize it in 4 areas of work that has been done by the Law Society in addressing the comments of FADF since 2019. First of all, we have put in place a new headcount of appointment in the Secretariat of the Law Society of engaging and appointing an AML executive who is a full-time designated professional in the area of AML. And this new headcount is also assisting our AML committee, of course, also helping the Standing Committee on Standards and Development, as well up to the Council on the following up the efforts or the previous efforts that the Law Society has been doing, and to do more work, which I will share now. The second one is the AML review that we have engaged. I think our president, Mr. CM Chan, has also mentioned that just now. It took place, I think, about a few months ago. Of course, we start our AML work, of course, much earlier than that. But we managed to do I would say, a very wide, it's actually a sector-wide AML review on all the law firms in Hong Kong, although by stages, but by now we have completed our sector-wide review on all the law firms in Hong Kong. So it's a desktop review by each and every law firm, and they will have to complete a questionnaire and then sharing information about what they have done for the all along in terms of their practice, in terms of their assessment, and also in terms of whether they have a AML policy which they have in place. At the same time, we also are doing now, reviewing the results of the AML to see what further help we could provide to the members. But we are pleased to say that the response to the AML review, even though we have not make it an absolute compulsory basis, we have a very, very good response rate from our member law firms. And we are now very busily analyzing the data or the information provided by our law firms, and we will see what else we could help our members in better fulfilling their obligations in the AML area. And actually, our president, Mr. CM Chan, has also mentioned that we have, for the very first time, developed our toolkit set for our members, giving our members a few areas of practical assistance, I would say. In terms of, first, we have a guide on alternative processes to verify a client's identity, and members will find it especially helpful given all the COVID situations where they may not be able to see the clients face to face, but they may actually still need to comply with all the KYC and CDD obligations. We also have, for the first time, a very detailed template of AML procedures that our law firms might adopt when kickstarting or actually at their different stages of file handling. And we also actually have also make it user-friendly in one sense, making it a simplified version where if members find that the file on hand is a relatively simple in nature, then they can use the simplified version. Whereas if they think that it is a more complex nature of a case, then they can, of course, refer to the complete version of the AML procedure template. And both the simplified version as well as the complete version have a further subdivided version of a corporate version and individual version. So that's a 2+2 set of procedure template that we have newly developed for the members as part of this new AML toolkit. We also, as I said, this is meant to be a help for our members to complete their client due diligence depending on their nature of the case. And we also have the AML leaflet for clients, and that is in both English as well as Chinese versions to cater for different business needs of our law firms. We also have developed and actually constantly revising our set of AML FAQ to address questions that members might have in terms of AML when doing their legal practice on a day-to-day basis. And this set of FAQ will be kept updated, especially when we are now reviewing and studying the responses from our more than 900 law firms in giving us feedback on their AML review. So this whole set of toolkits comprising of 5 items, I would say, actually more than 5 if we count on the subdivided items, then this whole set of new toolkit is meant to be not just a compliance driven, but at the same time, of course, an assistance to our members in better understanding and appreciating the AML obligations, and actually is better equipped to comply it. So they do not just know about it, but they are also better equipped to comply with it. So in terms of compliance, we think that both the compliance regulatory efforts, but at the same time support and assistance by way of enhancing their standards and helping their professional development. We think it is equally important in helping our members to tackle the new regime of the AML. We would also like to share that in addition to the 3 areas of efforts that we have shared just now, we also have a designated section on our Law Society website, which is specifically dedicated to the theme of AML. So you can either say it's an enhanced website or a thematic section, whatever we call it, but actually members can, if they have any question on the AML or they would like to look up any items like in the newly developed toolkit, then they can actually simply go to the Law Society website, click into that designated section, and then they can find everything that they need. And we offer all these free of charge for our members. And of course, this is also part of the results of having in place a new headcount with the AML executive. And so I, as the chairperson of the Standing Committee on Standards and Development, I always thank our members, our committee members, as well as the Secretariat for all the efforts in achieving all that so far. So having shared the efforts, recent efforts in that, I would also like briefly to cover the recent developments in the AML. So we have actually, as I shared, one of the pieces of legislation forming the AML framework is the Anti-Money Laundering and Counter-Terrorist Financing Ordinance. And we actually have an amendment bill, we call it AMLO, AMLO, Bracket Amendment Bill 2022. It's actually setting out the amendments to our CAP 615 Anti-Money Laundering Ordinance. These amendments is intended to come into place in 2023, middle of the year. So that's the 1st of June 2023. This round of amendments is not the first time, but this round is intended to further strengthen Hong Kong's efforts in combating money laundering or terrorist financing by introducing things like licensing regime for virtual asset services providers for the first time, also introducing registration regime for dealers in precious metals and stones. We also take the opportunity to introduce miscellaneous amendments to the AMLO addressing various technical issues identified in the FEDAF mutual evaluation in 2019, such as changing the definition of beneficial owner in a trust context to make it better align with all the references in other aspects of the ordinances. And in our toolkit for our members, we also have some guide to our members where they can only verify clients' identity in a non-face-to-face situation. So that's for the AML thing. And if I may very quickly, briefly, I think I still have 2 more minutes. And before I pass on to my also fellow council member Hin Han, I would quickly say that going forward, not just the AMLO will be further amended, but also the focus on the AML regime governance has further developments in the sense like we're not just talking about anti-money laundering, we're not just talking about counter-terrorist financing. We actually are talking about proliferation financing as well. So what is proliferation financing? I guess our experts here may already know, but for our audience here who might also revisit the definition of proliferation financing, I very quickly mentioned that as defined by FATF, is basically to provide funds or financial services which are used in whole or in part for the manufacture, acquisition, possession, development, export, transshipment, brokering, transport, transfer, stockpiling, or use of nuclear, chemical, or biological weapons and their means of delivery and related materials. So this is probably a new, not focus, but an additional area which the AML efforts on an international platform is also looking at. So we are looking at lastly in the Hong Kong context, this year 2022, we still have the money laundering and terrorist financing risk assessment, and we are very pleased to say that in 2018. Whereas for threats, vulnerabilities, and overall risk, Hong Kong has been further rated risk downwards to a medium level. In 2022, our assessment has been even a little better. We are now assessed as a medium-low level of risk, all in terms of threats, vulnerabilities, and overall risk. We are all assessed to be at a medium-low level. And this has been, we would say, a very pleasant result since it has been a further improvement since the result in 2018. So I think my time is up for now, and I will pass back to Lana, and thank you very much, everyone, for listening.
Dear Karine, thank you very much for this interesting introduction, and congratulations that Hong Kong is doing better and better in the evaluation with regards to anti-money laundering. Yes, and also very impressive efforts that you have been putting into the development of tools. Yeah, it's amazing to see that you also provide processes for your law firm. So for the law firms to look at, which I personally think is for the benefit, especially for lawyers who don't have maybe the financial means because they're not a big law firm to develop toolkits by themselves, or to get in an advisory to develop processes for them to comply with the law. So this is really a very good effort that you have been working on, very impressive. So, and with this, I would like to hand over to the second expert from Hong Kong, which is Hin Han Shom. And Hin Han Shom is a senior associate and solicitor advocate, able to be heard in the High Court and the Court of Financial Appeal. She has conducted various litigation cases, has represented clients in applications in the District Court and the High Court. She's heavily involved in the commercial practice and has experience in mergers and acquisitions, contract drafting, with special interest in legal compliance and the use of technical tools. Hin Han often advises clients on data privacy laws, drafts privacy policies and website terms, and provides practical solutions to clients in relation to cybersecurity incidents. Ms. Shom, please, the floor is yours.
Thank you, Lana, for the very kind introduction. My colleague Karine has given a very good overview of the laws in Hong Kong relating to money laundering, and also in terms of the Hong Kong Law Society efforts to try to help Hong Kong lawyers comply with the relevant regulations. So I guess my part will be talking a little bit more about the risk management and the other efforts that will try to help lawyers to keep abreast of the changes. As mentioned by Karine earlier, the main legislation that deals with money laundering, or actually Hong Kong has a series of legislation that touches upon money laundering, but the main ones that we look at most of the time is the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, the Drug Trafficking Recovery of Proceeds Ordinance, the Organized and Serious Crimes Ordinance, and also the United Nations Anti-Terrorism Measures Ordinance. So those 4 ordinances actually have quite similar wording in terms of their money laundering offense. Specifically, the anti-money laundering and counter-terrorist financing ordinance, we call it the AMLO, as Corinne mentioned earlier, the drug trafficking one, and also the organized and serious crimes, the OSCO, we call it in short form, have very, very similar wording. It states that a person commits an offense if knowing or having reasonable grounds to believe that any property, in whole or in part, directly or indirectly represents any person's proceeds of an indictable offense. And he deals with that property. So dealing with property, committing an anti-money laundering offense requires not only the actus reus of dealing with the property, but it also requires the intention. And the intention is actually very wide in scope. As long as someone either knowingly or has reasonable grounds to believe that any property is part of this indictable offense, they could meet the mens rea ground. So this might be quite difficult for most people to comprehend. And in fact, there has been one case in Hong Kong where a solicitor was charged and convicted with money laundering, but upon retrial, the solicitor was acquitted. And it came down to the mens rea of whether that person was dealing with the indictable offenses knowingly or believing reasonably that the property that was being dealt with might have been indictable offense related. So in our risk management regime and under the Law Society, we actually offer free risk management courses run by the Academy of Law. And a recent one that we've been working on is a risk management course solely dedicated to anti-money laundering issues. And in fact, that course was actually finalized in October 2020, so just a couple months ago. And it includes a lot of the updates in relation to what Corinne mentioned in terms of the risk assessment of Hong Kong, in terms of the relevant overview of the laws, in terms of the amendments to the AMLO, which include the updates relating to the virtual assets and also relating to the dealers for precious metals and stones. But it also helps to provide guidance as to how to interpret the law. So Hong Kong has a series of money laundering laws. And as you all know, Hong Kong is a common law jurisdiction. So the case law does affect how the laws are interpreted. There have been around 3 landmark cases which confirm how the intention, how the mens rea is to be interpreted in terms of committing the money laundering offenses. And a most recent case relating to the intention is one that was heard in 2019. And it's the case of Hong Kong SAR versus Harjani Harish Muralidhar. So in this case, once again, the courts confirmed the correctness of the earlier tests, where one's belief of whether they're dealing with proceeds of an indictable offense is not only 100% subjective, not only in relation to that one person's belief, but it also has a second limb. So if I may go through the 2 limbs, it may be more clear. So the first limb of the Harjani test is what facts or circumstances, including those personal to the defendant, were known to the defendant that may have affected his or her belief as to whether the property was the proceeds of crime. So whether that person would have known anything to believe that those proceeds were tainted. So this is a subjective test, really based on whether the accused knew what the nature of the money was. But then there's a second limb, and this is the objective limb to the subjective test. And this is, would any reasonable person who shared the defendant's knowledge be bound to believe that that property was tainted? So in other words, based on what the defendant knew at that time, would a reasonable person believe that all that money was still okay, was still innocent and not tainted? Or would they actually develop a suspicion, a belief that that money could be from problematic sources. So it's really a common sense approach, whether a right-thinking member of the community would have reasonable grounds to believe that that money is part of indictable proceeds. So this is a confirmation of the tests that were established earlier, but once again, this case law provides clarity as to how to apply this test, how to identify whether the elements of the money laundering offense are satisfied, all the elements are satisfied in order to actually commit a defendant. So in our, back to the risk management course, in our risk management course, we actually go through recent case law, including the Harjani test. And we also look to the earlier case law to understand and distinguish the differences, and also to keep abreast of the changes that the laws will continually, that will be present with all the laws. With the pandemic happening, we have increased a lot more online transactions worldwide. And in fact, a lot of our legal services have been changed so that there's a lot more transactions and a lot more meetings and events that are held online. And this also increases the money laundering risk, because when we intake clients that we cannot meet face-to-face, there is a risk that we're not conducting the relevant client due diligence or the know your client necessities. And as Corinne mentioned, the Hong Kong Law Society has been very aware of these challenges. And so they've come up with a series of toolkits in order to assist in ways to help conduct verification of identification of clients. But there's also other courses provided by the Law Society to help members be aware and sensitive of the risk, because ultimately it's the risks that we don't know that are the highest risks. What we don't know that we don't know are the risks that might snowball and become the threats to our career and to our reputation. And so the Law Society has also been developing and constantly updating the risk management courses in relation to cybercrime, and also in relation to dealing with digital technological tools and digital tools, in order for us to be aware of the potential pitfalls to money laundering. And this includes the increase in cybercrime cases in Hong Kong. As you know, cybercrime cases come in a variety of ways, but one of the most common ones that we see is where a party is asked to transfer money to another account, which happens to be an account of a fraudster. And this money is then washed. It's then transferred to a series of other recipients, subsequent layers, we call them. And then it will somehow, with enough layers of distancing from the origin of the source, that money could potentially be washed and be back into the system without people knowing. And there are a lot of cybercrime cases, unfortunately, that have arisen worldwide, and Hong Kong has been no exception to becoming one of these areas where money might be transferred to a Hong Kong bank account. So with cybercrime, there is an increase in money laundering risk. And this is an area where lawyers have to be more sensitive and aware of the ways to try to not only prevent cybercrime within their own firm so that they don't accidentally fall victim to the whole scheme of things, but also there are courses to enable lawyers to understand what steps to take to more quickly stop the money laundering, so that it can be stopped earlier and doesn't have to go through more subsequent layers of being laundered. There's also a lot of informative programs and events run by the Hong Kong police, which target specifically on cybercrime and money laundering. And as Corinne mentioned, there's the JFIU, which is run by the police and also the customs and these law enforcement agencies assist to help members deal with reports of suspicious transactions. And there's also a lot of promotional videos and information provided by the government to try to bring more awareness to people generally, to the public generally, as to money laundering. Because ultimately, if their money is stolen and it's laundered, for lawyers to help, the victims have to report quickly and have to locate lawyers quickly to assist in stopping and freezing the bank accounts and stopping the transactions from further dissipation to other layers. So ultimately, it's a joint effort between not only lawyers, but also enforcement agencies to try to curb new ways of money laundering that have arisen as a result of the changes in our society. So I'd like to close with that, and thank you.
Dear Hin-Han, thank you very much for your presentation. I would like to invite all participants now to type in questions into the chat function or the Q&A function. I can see both of them, so I will read them aloud. Yeah, now we have one from one attendee. I can also allow it to talk. So it's Ken Benjamin, I think. I cannot see the whole. Can you can unmute yourself and ask the question. You are now in the panel. Mr. or Mrs. Tao, please unmute yourself. You should be able to do this now. I see your hand risen. Yes. Hello? We cannot hear you. I think the microphone is not working. No, it's not working, unfortunately. Maybe you can type in your question in the Q&A function. Yeah, and maybe while you do so, and if I don't receive other questions, I may raise questions by myself. So I have actually a question to Laura Funke with regard to the auditing, and maybe then subsequently we can also ask the Law Society of Hong Kong to answer this question. It's when you go to the law firms, it very much depends on the size of the firm and also on the information you have to screen there. I'm thinking of, let's say, the office of CMS in Munich has maybe around about 70 lawyers, and they handle cases, M&A cases, which have a very broad context. So you have M&A where a lot of foreign parties come in as well. So how do you manage this? Do you take in another audit firm to help you? And if yes, how can you finance this? I mean, it costs something. Do the law firms then have to carry the cost to prepare this kind of audits, or how does it work?
An additional audit firm would rather be nice, but yeah, we can't afford it. So we have to do it by ourselves. We just 1 or 2 months ago had an audit, an on-site visit in a rather large law firm. So we did a preliminary search via their website to see who could possibly be an obligated party, because it doesn't make sense only to visit 1 or 2 lawyers. That's true. It does make sense to visit a huge group of lawyers in one go. So we are done with this specific law firm. So we did this preliminary search, found about 50 persons we thought are pretty likely obligated parties. Others, for example, are only doing something in privacy law and so on. So it was not that likely they were obligated. And then we narrowed it down further and thought, well, some of them were only lawyers for 1 or 2 years. They were rather young. They won't have that many contact yet to an entire transaction. And we focused on the partners, they focused on the senior lawyers, and had in the end a group of about 15 or 20 people. So we wrote them, we wanted to conduct an on-site visit. We went there with 3 people from the Munich Bar Association, and then we divided them into groups. We did a group thing at the beginning where we checked up what the law firm as such does to prevent money laundering, how the risk assessment of the law firm is done, and what are the specifics they do to prevent money laundering, to further knowledge about anti-money laundering measures in Germany. And then we picked them out one after the other to short investigation. They came for about 10 or 15 minutes each. They talked about the individual transactions they did. They showed us some case files we demanded to see. They were pretty well prepared, so they had everything already in the room we asked them to see, and it went pretty smoothly, but still we were there an entire day. So it's possible, but yes, it's pretty time consuming.
And how is it done in Hong Kong?
Well, if I may kickstart, and of course, our Vice President, Mr. Amrale Nasir, and my fellow council member Hin Han might add to anything that I might have missed. Firstly, I would say we do actually have the, if I may say, a requirement for law firms to have a designated person or partner, because in Hong Kong, basically, it's on a partnership model. Even it's a limited partnership, we're still on a partnership model. So we actually in our recent AML review, we actually ask the law firms who in the firm is the designated partner or person who is responsible for looking after the AML compliance matters. But of course, we do have our own compliance regulatory function, and we are not subject to like investigations from the Department of Justice, not like that. We, the Law Society of Hong Kong, regulates all the solicitors in Hong Kong. We currently have like 13,000 solicitors, about 11,000 having practicing certificates. So on that basis, we do the AML review, and we provide the guidelines, etc. So of course, one of the so-called room for improvement as identified by FADF is that we more on the guidance or the providing more assistance for the members. So that's why in this round, while we do not say there is a change as such, we have been doing the AML, we have discharging our AML obligations for a long time, as I shared just now. We're actually sharpening our supervisory focus as well, and that's why we have been doing all the getting additional headcount, and we're actually doing the toolkits as well as the review, etc. Because as identified or observed by FADF, that they wish us to not just to help our members, but also to give a more attention in doing the supervisory part as well. So let me pause here and see whether our Vice President and my fellow council member has anything to add.
In hand first.
Thank you, Karine and Marali. I agree with what Karine has mentioned. In terms of the regulatory role as a law society, we not only regulate, but we do try our best to ensure that our members benefit and understand what is required of them. And so, as our chair, Lady Standard Developments has mentioned earlier, we constantly review and update the toolkits that are relevant in order to help the members. And we also make sure that we listen to what the concerns are. So there have been, since the development of a questionnaire that was circulated to all the firms, there were some questions raised by members as to what exactly they're supposed to do. Does it negatively affect them? Is this information going to be used against them later? And this type of these type of queries are completely understandable. So our Standards and Developments Committee then issued a letter in response to all these queries to ease the concerns and let members know exactly what we're doing, why we're doing the things we're doing, and how we're here to help. So I think in terms of the developments and the moves that we're making, we do try to ensure that the channels of communication are open to our 13,000 members, and they can just talk to us and let us know what concerns they have, and we will respond appropriately. Thanks.
For my part, would be more general in the sense that we are, as Inhan and Karine have said, that we are a self-regulatory body, but we are both a trade union as well as a regulator. So we play those two roles as fairly as we can. Karine's subcommittee deals with the standards and development and making sure our members have all the benefit and understand the standards, as well as providing facilities to enable to deal with the regulatory issues that arise. But in addition to that, you might be interested to know that there are other avenues which FATF would be involved, and that is that if you have a certain sum of money exceeding a certain sum of money paid into cash into banks, the banks automatically report that to FATF. We also have every year accountants which audit our firms, not for AML, but they audit our client account monies in our firm. So if somebody has, if you're a sole proprietor and suddenly you have $100 billion going through your account, it's likely that the accountant would inform JFIU. So we have this additional feature. We also have designated partners, but our laws also obligate anyone to inform JFIU of a suspicion. So if a designated partner doesn't, then of course there's anyone can refer that matter. And of course, the other issues we've seen is the banks, when we open accounts, if you look at the bank opening forms, they're practically shifting all the responsibility to the lawyers, saying, do you know your clients? Do you know where the money's come from? All of those issues that are matters that banks are expected to report on in relation to their AML obligations are put onto law firms, because in a sense, we also deal with client money. And so those are some of the general aspects which don't directly relate to AML, but are important features that buttress the AML regulations.
Or if actually I may further add a little observation to what Amrali has shared, because I run my own law firm as well. So from a practical point of view, to add to our Vice President has said, sometimes when a client, or actually like in a property transaction, the vendor receives a check and try to deposit that check into his account, or actually if they may actually be in an urgent need to use the funds, then they may opt for the option for a direct transfer of funds instead of going through the normal check clearance procedures. Then actually the bank might call up the issue of the check, which is the law firm, although we do have the new system of the PAPT, the property payment scheme, which is quite new in the sector. But most of the time, as I observe in our daily practice, most in property transaction cases, clients still opt for the traditional way. So if there are big amounts of checks going through clients' own personal accounts or going through law firms' accounts, then the bank might actually be calling up the partners or the signatories in the firm to ask whether this check has really been issued, and how much do you know the check has been issued, who is the recipient. That's a kind of question. So there are practical steps that's happening every day like that. So just to add to what our Vice President has shared.
We also have regular risk management courses on anti-money laundering and risk management courses. We have 15 CPD points, of which 3 have to be on risk management. And they have a whole host of courses that can be taken on management of firms. One of them is on risk management, others on fraud, and a whole host of other risk management courses as well.
That's for the law firms.
For individual solicitors, as part of their continuous professional development, some of the courses that the Law Society has developed. In fact, this new one is in hand. I think it's only this month, right? Or last month it started. A new one taking into account some of the cases that Hinhan's addressed in her talk, as well as other features of the practical management of a firm in relation to money laundering, and giving examples where firms, lawyers have become involved not in Hong Kong. We have not had any case except one which was one on appeal, but in other jurisdictions where we have had solicitors who've been caught up with money laundering cases.
Maybe from our side, from the German Federal Bar, does anyone want to add something on this question, or maybe share some experience?
Most experienced probably is Ms. Funke, since she's active, specialized in this field, and doing the nice on-site visits. You get new friends.
Here, if the acres do offer also a lot of information, a lot of working material for our lawyers, and this year we really saw that there is a lot of progress happening, because last year, 2-3 years ago, we saw that our lawyers often ask, oh, there is an AML directive, I didn't know that. There's a national act, I didn't know what I had to do. There is no information. Well, there was information because we promoted it quite heavily, but not everyone took part in it. And we thought that during the last years, there was a huge surge in interest in all the things we offered as a at the Bar Association. There were lots of online things where they could take part in to learn about the AML obligation. We had on site in our office in Munich lots of events concerning money laundering obligations, and we thought that more and more lawyers call us to ask, well, there is a suspicious transaction, someone wants to deal with €500,000 and somehow it's a cash transaction. Is it legal, and what can I do to ensure that I have no problems with the law? And we also see that the kind of questions we get are more and more distinguished. In the beginning, it was still how do I do it? Identification, is it really necessary to see an idea? Am I allowed to do a copy of the idea? And nowadays, it's more like, well, I have an online transaction, but I still have to identify my client. How do I do this? How can I use video identification? And I already read there are internationally, there are possibilities for this, but Germany does not provide an official line to do it. How can I make it possible? Because there are COVID problems, we can't meet in person. So we really see how the lawyers work together with us to get a better understanding of AML problems. And we also learn from our lawyers, because with every question they pose to us, we see which are the relevant practical issues they have, because we can think a lot about theoretical problems in our working group and at our regional bars, but it's not always the same problem the lawyer actually working the relevant transaction face. And so we learn from each other. It's a progress, and I think it looks really bright for the future. I have a huge hope that we can aim to develop AML strategies that really have an impact to prevent money laundering and terrorism financing in Germany.
Maybe what I can add is that currently the German Federal Bar tries to assist lawyers by electronic means in complying with their obligations under the AML Act, but so far we don't have a sufficient legal basis to do this support. We're trying to change it. We're trying to convince the German legislators to give us this legal basis to support lawyers in complying with their obligations, and then we could provide them with the with electronic tools for these purposes, and that's what we intend at the moment.
Thank you very much. I would like to ask Benjamin Tao again to raise his question. Is that possible now? Maybe we try again. Oh, I think your microphone is still not working. And then maybe again, I ask whether anybody else from the attendees has a question. Please type it into the Q&A function or the chat function. I will read the question aloud. So also no, then I'm turning to our experts. Maybe you have any special questions you would like to ask the other side, and then please go ahead if you have.
When can we see each other again?
We have a number of international conferences. We hope to meet each other if we happen to cross each other. And I'm sure with Hong Kong opening up now, there will be more international trips, and hopefully we will be able to meet again.
Yes, as CM mentioned already, we were able to have a meeting during the Law Asia conference in Sydney, which was very good to touch base again. And I really hope that you will attend the Law Asia conference next year in Bangalore. But I also hope that it would be possible to maybe send a delegation to Germany. You're always very welcome to visit us in case you would like to learn something about a specific topic. We can always organize this, an expert exchange, visit authorities. So yes, feel free to approach. I don't know what is the quarantine regulation right now in Hong Kong. I think you still have some days, but it's rather, isn't it rather, it's not mandatory, so you can choose it by yourself, right?
Yeah, there's no quarantine in Hong Kong anymore.
Not anymore. So even if we fly in, we also don't quarantine anymore.
No, you have to go through a test. That's just once, but there's no quarantine.
We will be able to travel again to Hong Kong.
Yes, hopefully.
Yes. So with this, I would like also to hand over to you to give your closing remarks. I see we don't have any further questions from the audience. And yes, please, Amirali, please close our event.
Thank you very much, Petlina. Our objective in signing an MOU with other jurisdictions is to advance the aspirations therein mentioned. Our MOU between the German Federal Bar and the Law Society of Hong Kong was signed in May 2016, and it has, I might say, been a very successful one. We have also had physical meetings at various international conferences. As far as I can remember, I was present at a number of them since 2019 and before that, as well as a visit to Germany by our president to observe your new IT system for German lawyers to interact with your courts in its inception, also in its design stage. Our last joint webinar with the German Federal Bar was in September 2021 on the topic of law tech. Goods and services, including legal services between Hong Kong and Germany, have always been an important part of business and cultural exchange between our two jurisdictions. Areas covered by the Law Society speakers, Corinne and Henhan, in this webinar have covered an important aspect of legal services, as well as the illegal services and relevant AML provisions in Germany within the context of trade and services in our joint jurisdictions. The speakers have shown how close the laws of our two jurisdictions are in relation to compliance with AML provisions, And I'm glad also to see that despite the fact that we're from different civil and common law jurisdictions, the provisions of secrecy, as you would call it, and professional privilege are as important to you as they are to us as well. This concludes the Law Society's joint webinar series and meetings with our MOU counterparts in 2022, which includes Spain, Georgia, USA, Italy, Germany, and meetings with Korea and Japan. We look forward to continuing our collaboration in the future, hopefully in person, and to meeting you in international conferences in the future. And I'd like to join Hin Han, Corinne, to wish you all a Merry Christmas and a Happy New Year. Thank you very much.
Thank you. And now we are closing this webinar, and also from Germany, Merry Christmas and a Happy New Year, and hope to see you all in 2023.